a Ghanatube so ebusian form dot for slow women science so emamo akwa ababium matna cd na ewie insem ahodo enkoso ewo oman ganim na entempara no me ntwentwen so emfama mo no yebeka kotie insem ahodo bi a ekoso ewo oman ganim.
The Lord Chief Justice's purported petition. This will not be the first time a petition is coming to the president for the removal of the Chief Justice. This one is particularly worrying because of the undertones. Now, the story came in just as we were coming to press. So tonight we'll not be able to do a lot, but Thursday we'll bring you so much detail about what we know about the moves, the actions, the shenanigans, everything that is being done within the courts of some of the members of the NDC. We know that there are some of the members of the NDC who find this intention to remove chief justices completely preposterous, and they are also sounding their voice to President Mahama. But there's a lot inside to share with you now. The petition that has gone to President Mahama is not completely disclosed in Felix Kwasi Ofosu's document. But he just says that there are 3 petitions. So let's just quickly take you to the constitutional provision that perhaps will be used. This is the petition here. This is the document from Felix Kwasi Ofosu. It's today, Tuesday, 25th March. President Mahama consults with the Council of State on 3 petitions for the removal of the Chief Justice. President Mahama, it says, has received 3 petitions from various persons seeking the removal of the Chief Justice. The President has forwarded the 3 petitions to the Council of State to commence the consultation process mandated by Article 146 of the 1992 Constitution. I believe that's what it is. Now let's get to Article 146 and see what the provision provides. Article 146, removal of Chief Justice of the Superior Courts, removal of justices of the Superior Courts and chairman of regional tribunals. It says 1461, a justice of the Superior Court or a chairman of a regional tribunal shall not be removed from office except for stated misbehavior or incompetence on grounds of inability to perform the functions of his office arising out of infirmity or body of mind. 6 says, where the petition is for the removal of the Chief Justice, which is what we are currently dealing with, the President shall, acting in consultation with the Council of State, appoint a committee consisting of 2 justices of the Supreme Court, one of whom shall be appointed chairman by the President, and 3 other persons who are not members of the Council of State, nor members of Parliament, nor lawyers. 7. The committee appointed under Clause 6 of this article shall inquire into the petition and recommend to the President whether the Chief Justice ought to be removed from office. 8. And this is the important one. All proceedings under this article shall be held in camera, and the justice or chairman against whom the petition is made is entitled to be heard in his defense by himself or by a lawyer or other expert of his choice. 9. The President shall, in each case, act in accordance with the recommendations of the committee. This is very interesting, and we're going to give you the history of this provision of the 1992 Constitution and show you the philosophy that was behind it. We'll come to that in a minute. Now, these are the people who are going to be very important at the Council of State in dealing with the petition. Now, why do we say they are important? Because Sophia Akufu here, we understand, chairs the Judicial Committee of the Council of State. Now, this is a judicial document forwarded from the President's office to the Council of State. In those circumstances, it will most likely go to the Judicial Committee of the Council of State, and there, Sophia Akufu is chair. So she would have a lot to do with this petition. Also is her Lordship Justice Adinira. I think she's also Sophia Agency. I can't remember her first name. Justice Adinira, former Supreme Court judge, is also on that committee. So these 2 ladies are going to be very, very important in making the decision as to whether the President, as to whether a prima facie case has been made or not. Now, the letter from Ofosu Kwasi is not clear. It doesn't say the word prima facie. It's not too clear whether the Council of State is invited to make a prima facie case, or that a prima facie case has already been made by the President himself and is forwarded to the Council of State. Because the law says the President in consultation with the Council of State. We are not sure. The law didn't say what level of consultation, whether the Council of State should assist the President to make the prima facie case, or whether that case the Attorney General assists the President to do so. We're still learning, and we'll find out what these details are. But these are the important 2 important women and 1 man who are going to make this decision either to the left or to the right. The Honorable Do Ajaho, I'm not done, can I have? The Honorable Do Ajaho, former Speaker of Parliament and former MP for Aveno Ave, many years ago. He was the chief whip of the NDC. Is the chairman of the Council of State. And these three persons, two ladies and one man, are going to be very instrumental in making the decision. So now, Sophia Akuffo herself has a bit of history with this, because here is an article here. It is November 2018, and it says, remove incompetent Sophia Akuffo as Chief Justice, Mensa Thompson. A petition was sent to President Akufo-Addo that Sophia Akuffo had engaged in some land, cantonment land, Laboni land, something, and therefore they were asking for her removal. So Sophia Akuffo went through that process and she survived, because as far as President Akufo-Addo was concerned, it was not substantive enough to grant a prima facie, so he dismissed the petition. Also here, Akufo-Addo petitioned to remove incompetent Chief Justice, and that was also in 2018. So Sophia Akuffo herself survived at least two petitions against her for her removal, which Akufo-Addo thought was completely flimsy, preposterous, and out of turn. Now she would have a very important decision to make about the Supreme Court that she left behind, now led by Gertrude Tokonu. Sophia will have a very important decision to make as to whether Gertrude Tokonu, the petitions that have come, those three petitions. Now, on the next edition of our program, we're going to, we think we know at least one of the petitioners. We think we know one petitioner. And we're going to give you the history of the petitioner and his machinations within the court system, particularly the Superior Court of Judicature, the High Court, the Court of Appeal, and the Supreme Court. We're going to tell you a lot, a whole lot, because we had heard about the petitions that were on President Mohammed's desk last week. So here we had been preparing our research in case the petition comes. What are we going to do? We were just taken by surprise this evening. We didn't know that it was going to come today, but we had heard last week that there was one petition before the president. So that will be dealt with in extenso, as it were. Now, let's get back to the constitutional provision, and I want to talk about these two men. I just have 2 more minutes to do the story and I'm out. Now, this is Professor Kwame Nahoy, and this is Mr. Chachuchi Kata, but he's also a professor because he's quite learned. Now, these two men were responsible largely for drafting the 1992 Constitution. I think they did an excellent job. Now, they both had responsibility. Mr. Chikata, I guess, had more responsibility, because it was Mr. Chikata's responsibility to deliver a constitution that will be palatable to the military junta, to aid the decision by Rawlings to transfer himself from a military ruler to a civilian ruler. In the circumstances, so Chikata's job was very difficult, and he discharged it with a distinction. What he did, and that is why we are shouting about constitutional amendment, because the constitution has served that purpose of making it look like the authority of a military junta in the executive, so that a military man who wants all the powers allocated to him will find the constitutional process palatable and join it, so that we can have a democracy. So they did a good job, didn't they? They convinced the military strongman J.J. Rawlings on the armored car holding an AK-47 to drop the AK-47, jump off the armored car, wear a suit and a tie, and sit in the Land Cruiser and go to Independence Square, stand without taking a salute, and watch the parade without being military, because the powers that he wielded as a military officer, as a military ruler, were the same powers that the Constitution granted him. In those circumstances, we believe that let's look at the provisions. The provisions of Article 146 were guided in a certain way. It was intended so that when the Constitution takes effect, hopefully with Rawlings' ruling, and he was unhappy with some high-profile public official over whom the NDC and the military did not have control towards his appointment, either as a Supreme Court judge, as a justice of the Superior Court of Judicature, or as a public official, regional tribunal head, electoral commissioner, all of those things, that if the military junta were unhappy with some appointment that had been made on their blind side because of the circumstances of the time, Article 146 will be available to be able to get them removed by impeachment. So if you look at Article 146, it is such that the real decision-making part of Article 146 is whether or not there's a prima facie case. If a prima facie case is achieved, the accused person usually does not survive. And he does not survive because of Clause 8 thereof. It says, all proceedings under this article shall be held in camera, and the justice or chairman against whom the petition is made is entitled to be heard in his defense by himself or by a lawyer of an expert. Now, why are these provisions being held in camera? Now, in camera, viewers, means that it is held in secret. There's no media. There can be no coverage. You cannot apply for the record. I don't even think that RTI will work, because RTI, that's the right to information, is an act of parliament. And an act of parliament is inferior to the constitutions of the provision. the provisions of the Constitution, so that an act of parliament cannot override Article 1468, which is directly prescribing an in-camera hearing. Now, the reason why it is in-camera, as we fathom, is because the military people did not want a situation where they needed a judge removed, a Supreme Court judge removed, a Court of Appeal judge removed, and then the general public will get wind of what questions were asked him and why he was removed. So they say that all such proceedings will be held in camera. So if you are accused of something, you go in camera and then the report comes. And you see, at the end here, it says that the president shall, that is 9, the president shall in each case act in accordance with the recommendations of the committee. That's quite serious. So the president doesn't have a view on the matter. So they're trying to sort of insulate the president from the processes, but those processes would have been completely controlled by the government of the day. So let's wait and watch this space. But in our next edition, we'll come with some very detailed analysis of why we are where we are with the current Chief Justice. And we all remember Professor Mills, may he rest in peace. And he said in his time, when he became president, there was a lot of pressure on him for this process to be used to remove the learned Chief Justice of the day at the time, Georgina Theodora Wood. Professor Mills stood his ground that he was never going to accept something like that. And he told friends of his that he's a law professor, he's a law-abiding citizen. What is the point about trying to remove a Chief Justice because when you're in opposition, you claim that her posturing was wrong? Professor Mills stood and said that I cannot do that. And then he told the Chief Justice, and then at a state function, he invited the Chief Justice for a dance, so that my friends, may he rest in peace, also Alhaji Bature, who were calling for the blood of the Chief Justice, they will see that the president has a very cordial relationship with the Lord Chief Justice. And Georgina would not serve this country well. She served this country absolutely well. So that was the spirit of Professor Mills. And that's what he did in 2009. And I'm not so sure why anytime the NDC comes to power, there's this clamor for remove the Chief Justice, remove the Chief Justice. It's happened in Professor Mills' time. I do also remember that during the Professor Mills' time, President John Dramani Mahama, who was the vice president, was very much against this thing about people wanting to remove Georgina Wood. I remember that he was one of the voices of conscience in the castle over this Georgina Wood matter. I remember that clearly. I've been a news reporter forever, so I was already a news reporter at the time. So I remember that. But let's see how these things shape up, and let's see if time changes people or if it doesn't change people. We'll find out. But because of this, I'm putting up this NDC rally song because Professor Mills' name is mentioned in it. This looks like very, very dangerous times for the sustenance of our democracy. Tonight, we have a big program on the Attorney General's press conference in this Ghana and under this constitution. Let's hope that it is not what we think it is.
Abuziafo medamase se mudi mechi emayekotie eye ensem no na meni se motie ama mo de comment ebreme e comment monye sa enfama me na menkinkai ema mo fefefe aha eye Ghanatube so bi on subscribe ya abuziafo to bo ase na subscribe na Facebook mi a eye notification bell no so se na bia ensem no medi tuma na wenya ne intempas mema we mfin so se obelike na afin so wa share in videos we e channel we so abuziafo aha Ghanatube so wonderful snowy sisi ade makramo